Hi, and welcome to EcoFounder TV. Today you're joined with me, George Gray, and I'm joined with a special guest, Eric Lane, down in San Diego. Welcome to the show, Eric.
Thank you, George. Thanks for having me.
Awesome. Eric is the blogger behind the Green Patent blog. He has also written a book called Clean Tech IP Protection, IP. And today he's going to share with us some insights for engineers and scientists going into the startup world and how you can protect your own innovations and technologies. So tell us a little bit about what you do there, Eric.
Sure. I am a registered U.S. patent attorney. I also do trademark work as well, and I do general intellectual property counseling for clients both large and small, from individual entrepreneurs to some of the largest clean tech companies. Most of my clients are in green technology, and so what I do for them is, I really help them protect their intellectual property, protect their technology via patent applications and patents, protect their brands via trademark applications, and then I help them manage, build, and grow their patent and trademark portfolios both in the U.S. and internationally.
Awesome, awesome. And so that's what you write about at the Green Patent blog as well?
That's right. To some extent, what I write about on the Green Patent blog does have to do with strategies for protecting green technologies, strategies for protecting green brands. The Green Patent blog has a lot of different types of posts on it. I do some company profiles where I talk about companies and talk about their technology by focusing on their intellectual property. I talk about some policy issues, intellectual property and climate change. I talk about patent litigation in the clean tech industry and other things along those lines.
Awesome, awesome. So what would be, if, say I'm an engineer or scientist, I've got some amazing, well, I think it's amazing technology ready to take to market. What are the very first steps that I would go through in order to get some protection set up?
Well, I think it's very important, first of all, to, at the very least, consult with a patent attorney
Right.
before you disclose your invention to anybody. The reason I say that is that any public disclosure, almost any public disclosure or offer to sell a product or sale of a product can be an event that would invalidate a patent if you file a patent application and get a patent later. So it's very, very important, particularly considering recent changes in U.S. patent law. Mm-hmm. And also patent law abroad in a lot of countries around the world where green technology companies file their patent applications, to at least consult with a patent attorney and actually have at least a provisional patent application, and we can talk about that in a little bit. Have some kind of patent application on file before you make any public disclosures
Right.
or disclose it to any potential partners, because there are some risks to disclosing the details of an invention before you file a patent application.
Wow, so when you're getting started, you've really got to get in there as soon as possible to make sure.
Yes, you do.
Right.
Yes, you do need to get in there as soon as possible for a couple of reasons. You don't want somebody else to go ahead and be able to file a patent application on your idea, because now it is a first to file system in the U.S., first to file system of priority. So the first one to file a patent application in the U.S. Gets priority. It's essentially a race to the patent office. But also, as I mentioned before, if you were to disclose the invention or somehow publish it, that could invalidate a patent later on. You would be ineligible for filing a patent application, and the patent would be invalid. But it need not be necessarily a long, expensive process. There's a provisional patent application, which is a somewhat cheaper option, which we can talk about.
Right. Awesome. And what are the, like, it seems to be that patent is a hard one for different industries. I suppose for clean technology, it's more straightforward. What industries are you? What industries are people coming to you with? Is it all like what can you patent? I suppose with technology, is it certain parts of innovations, the whole thing?
Well, you can patent just about anything, so long as it is what sort of what we think of as traditional technology. You can patent a whole system if the system is a significant innovation. You can patent components of the system, and I always suggest if there is a large system, a big new wind turbine, for example, that you look for both system level macro innovations and also some of the components, the blades, the rotor hub, whatever it may be. Patent those if there are innovations in those systems as well. The only areas where it's very difficult in the U.S. to get a patent is business methods, software, abstract ideas, algorithms, things like that. But and there is some of that in clean technology, but much of the what you think of as traditional technology is patentable so long as it's novel. That is, it hasn't been done, that exact invention hasn't been done before, and it's non-obvious. That is, it's a significant innovation, not just an incremental tweak of what's come before.
Oh, cool. Yeah, well, that makes it a lot clearer now. So maybe just enlighten us with the difference between patents, trademarks, and copyrights for some people that may not be, aware of the different types of protection.
Sure. So patents protect what we traditionally think of as technological innovations. Patents, the baseline sort of feature or requirement of an invention for it to be patentable is that it's useful. So anything you think of that is a useful technological innovation is going to be in the realm of patents.
Right.
Trademarks protect broadly speaking, brands. And this can also be just about anything, a word, a design, a slogan or phrase, even sounds, colors, and smells can be protected by trademarks so long as they serve as a brand, that is a source identifier. Consumers, they're used in such a way that consumers connect that brand with your company and the products or services that your company sells. So those are trademarks. And the last was copyright, you mentioned?
Yeah.
Yeah. So copyright protects generally creative works. So the traditional copyrighted materials that can be copyrighted are, anything you write, books, plays, screenplays, any visual work, any creative work, paintings and drawings and such, and recordings as well. Copyrighted.
Yeah,
and software code is copyrightable.
Oh, okay.
It's hard to patent software, but the actual written out software code could be copyrighted. Design drawings also could be copyrighted.
Right.
Technical drawings can be as well.
So there's a bit of flexibility with what you can and what you cannot.
There is some overlap, and yes, the thing to do really is to consider all forms of intellectual property, because not everything falls neatly into one or the other form of intellectual property. You might need to consider a bunch to optimize your protection. Yeah.
And you said you can was it trademark? You can trademark smells.
You can. Yeah. If
are there any examples of that? I've never heard of that one.
There are examples of that. For example, some companies that make yarn. Attach a smell to it, and that can come to be a source identifier if only that company uses that particular smell. Think of, say, a perfumed paper.
Okay.
that has a particular smell, or along those lines as well, maybe
Cosmetics, I suppose, that comes to mind.
well, cosmetics, but cosmetics there the smell is useful or functional. So
Right.
it's more likely to be something where the smell isn't directly related to what the product does. So like a wedding invitation maybe could have a scent on it. I don't know.
Right, right.
But yes, and just about anything.
Just about anything. Awesome.
Hmm.
Okay, and yeah. So for so what are some of the types of clients that you've been getting at the moment? Are they engineers, scientists? Are these the kinds of people that go to you for prediction, or does it tend to come from um, who are your clients?
Well, so there's almost always an engineer or a scientist involved in my clients. Now,
Okay,
sometimes it's an individual
okay,
engineer turned entrepreneur
right,
or scientist turned entrepreneur. Sometimes it's a large company where the CEO or is him or herself an engineer, or the chief technology officer, of course, is a scientist or engineer. But there's a big team involved, or multiple teams involved.
right,
And then there's in between. There's a bunch of small startups where you've got a CEO or CTO, and then you've got a business development person, where there are two or three people. Some clients are just technology licensing companies where you have one business guy, and then you
hmm
have one inventor who's
right.
an engineer. So it's quite a range, but there's always some kind of engineer or scientist involved.
Gotcha, gotcha. Yeah. And what would be any particular tips for scientists and engineers as far as um, getting in there early?
Hmm.
What's the process? You get in there early. Talk to the
Yeah,
walk us through past the initial stages.
sure.
Yeah.
Well, so I think the first thing is, I mean, if you have some kind of invention, some kind of idea for technological innovation or improvement, write it down. Write it down in such a way that it's something of a narrative, and it can be very brief. Here are the problems I see with the existing state of the art. Here's briefly my solution. Here's a more detailed sort of description of my solution and the different elements and components and features and how they work.
hmm
Here are some variations on it, and some detailed drawings, either hand drawn or through some kind of program, and that sort of thing is very valuable and can be should be updated over time, and that's the sort of thing you would share when you with a patent attorney when you retain a patent attorney. And the patent attorney can fairly easily turn that into a patent application. And as I mentioned, there's a non-provisional patent application, which is a large formal technical document that once it's filed, it gets in queue to be examined. And then there's a provisional patent application, which requires all the detail but doesn't have to be so formal. And
Gotcha.
that has a much lower filing fee and takes less attorney time, so it's a lot cheaper to get in. And that is a placeholder that gets you a filing date, gets you your priority, but allows you 1 year, expires after 1 year, allows you 1 year to decide if it's worth your while to spend on the more expensive and formal non-provisional application. So get that write-up done. As you're inventing and as you're working with it, as you're improving, and before you disclose it to anyone, once it gets to a point where it's close to being finalized, I would definitely consult with a patent attorney one or more times along the way. And then you file the patent application, and you get some back and forth with the U.S. Patent and Trademark Office, and they may reject it, and you may have to make arguments and amendments, and that's very common and typical. Um,
Yeah.
but getting that patent application on file is critical.
Awesome. Awesome. You're just getting involved, and it sounds like the process of going back and forth must be quite tedious.
Well, it can be. I try to be proactive. I mean, the U.S. Patent and Trademark Office is staffed by patent examiners, individuals who are assigned these applications to examine them and
Yeah.
do prior art searches, and they're they have their job to do, but they're most of them are amenable to discussing it, so I get on the phone with them and try to come to a meeting of the mind so it doesn't take too long and doesn't get too tedious,
Awesome.
to try to get a granted patent as soon as possible.
Awesome. Yeah. Yeah, that would be one of the things that would frustrate me, going back and forth. But like you say, it's a process that your patent attorney takes the large role in.
That's right.
Yeah.
That's right.
Yeah, well, thank you very much, Eric, for sharing all your insights today. It's much clearer now hopefully to all the engineers and scientists watching, how the process goes about as far as protecting your innovations, protecting your technology. So thank you for sharing.
You're welcome. Thanks for having me.
And we've got one last question on the show.
Sure.
Which is, what is one thing that you've learned in your career, or that you've learned from intellectual property and protection, that you would share with our audience today? What's one thing that you might share over your career that'd be helpful?
Let's see. One thing that would be helpful. I would say to always consult with your patent attorney before you make any moves, because I have seen too many people come to me when it's too late and things have already
Right.
it's already gone sideways. One thing I've learned is it's always, even though patent protection is expensive, it's always cheaper to do it right the first time than to clean it up afterwards. And the other, a corollary of that is, if there are multiple inventors, then always make sure you get if they're working for the company, have them sign something that either obligates them to assign their inventions or actually does assign their particular inventions to the company. So, because people don't always stay together. The startups are sometimes like marriages, will split up, and you want to be sure that the company has the right to the invention, even if an inventor goes off somewhere else.
Okay. Well, thank you very much for that.
You're welcome.
And where would people find you, Eric, if they want to find more about your work and the work that you do?
My website is greenpatentlaw.com, and the blog is greenpatentblog.com.
Awesome. Well, thank you for joining us today.
My pleasure. Thanks for having me.
And that's all we have time for today on EcoFounder TV. If you enjoyed the interview, make sure you check out the blog post below if you're watching from YouTube, and make sure to subscribe. Thank you very much.